I hired an attorney.
Partner at Tocci.
No, they did.
For the zoning,
Centerville.
at the zoning board, yeah. So we figured, well,
I manage.
that's kind of, we've got to hire one as well.
Practice group, and we provide with the Cape Cod Chamber and the Department of Labor, we put on this seminar every year to provide information and advice on compliance with wage and hour laws, very specific to the hospitality industry and to Cape Cod businesses. So we thank you all for attending. It hardens us, makes us realize there's a lot of folks out there in this room who want to learn and want to comply, and that's very important. I think when it comes to the Department of Labor, my experience has always been that they want to know you are not taking advantage of employees, that they know these laws can be very complex, sometimes hard to understand and comply with. And I've always felt that they're not in business to put you out of business. They want compliance. They want to make sure your employees get paid, though, everything they're owed. And it's been my pleasure to work with Nanci Siciliano, Nancy Mills, now retired from the U.S. Department of Labor Wage and Hour Division. Nancy was a longtime investigator. I think we first worked together over 20 years ago on a matter, and always found her wonderful to work with, even though she was sometimes tough on my clients, as she should be. But she's a font of knowledge, and she's been there out in the street performing investigations for DOL on wage and hour investigations and audits. And with her is Tom Carroll. Tom is the community outreach and resource planning specialist for the DOL. And he also has been an investigator for a long time, and just a wonderful source of knowledge for the Department of Labor. And they're going to speak in just a minute, but first I'm going to introduce my partner, Matthew Lee, who runs our immigration practice group here in Centerville. And Matt is going to talk a little bit about seasonal workers and the immigration aspects of seasonal workers before we get into the wage and hour.
Good morning, everyone. Principally, I'm going to talk about the H2b obligations. Many of you have H2b workers. You sponsored them, and they're employed with you as H2b workers. We're not going to really talk about J1s because we don't do much with J1s. J1s are covered by the agency that sponsored them to come into the United States, and they're more they're the experts on J1 compliance. Okay, I will touch upon them in a second. I'm just going to spend about 15 minutes. Unfortunately, I've got to run, but highlight some of your obligations under the H2b program. So many of you are sponsoring H2Bs. The first thing is you're not allowed to employ an H2B that you did not sponsor. So an H2B visa is not a unlimited work visa for the individual worker. They can't go work for any employer they want. They can only work for the employer that sponsored them. So if you have someone that comes knocking on your door, they have an H2B visa for the restaurant or hotel across the street, they are not eligible to work for you. Okay. Number two, as you sponsor H2Bs, you have to complete the temporary labor certification process. That's the ETA 9142B. That was started for you probably in January or February, and it's very job specific. And when you sign that form, the 9142B, you promise to abide by certain obligations for having that worker and how you're going to treat U.S. workers at the job that's doing the same type of work. Okay, that is your compliance obligations with the U.S. Department of Labor Employment Training Administration, which those rules and liabilities are enforced by Department of Labor Wage and Hour. So that would be Tom's group. So the first thing is read your 9142B. So you have to pay what you promised to pay on that form, on your temporary labor certification. You have to pay what you promised to pay for the time period that you requested, for the hours that you specifically put on your form, and you have to also agree to other obligations as you stated and you signed off on. So the most important thing is read the 9142B and read Appendix B, which has 32 additional obligations that you have signed off on. First thing is, all wages to the H2b worker must be free and clear and unconditional. You should not be deducting anything from pay unless it's 100% voluntary. Our office always recommends that, that other than taxes, you don't deduct anything from pay. If you're going to deduct meals and boarding, and most employers in the Cape will try to arrange for some type of housing for their workers. I think it's foolish to try to take their rent and pay it to the landlord. I would not do anything within the paycheck. If you're going to deduct anything from their paycheck, it should only be taxes. You will not be able to comply with the rules under the wage and hour, under the FLSA, for how much you can charge per week for housing, how much you can charge per week for meals. Okay, it's a very complicated formula, and you have to do it every single week to make sure that you're compliant. So we don't recommend you deduct anything from their pay. Again, read the form. You have to comply with whatever you said was your single work week from whatever it is, Sunday at 1 a.m. until the following Saturday night at midnight. How many days a week you are guaranteed to offer, and how many hours a week, no less than 35 hours a week that you're guaranteed to offer. So whatever you stated on your 9142B labor certification, you're stuck with. You have to pay wages no more than 2 weeks apart, and you must offer work within on the first day of need that you requested on your 9142B, or within 1 workday of arrival. Okay, you cannot bench your folks and not employ them or pay them for 2 weeks because you don't have the work yet. If you said April 1st and they showed up on April 2nd and you're still not open yet, you still got to offer them the wages, offer them the hours and pay them the wages. However, there's one exception to that helps a little bit. We'll talk about that in 1 second. All right, your obligations end until the end of the H2b certification period. So if it's April 1st, October 30th, your obligations end on October 30th, unless you terminate them early. If you terminate them early, there's additional obligations required of the employer. Really important, and this is where you're going to have wage and hour show up. You must pay all corresponding employees the same wage and terms of employment as you do the H2b. So if you have 6 dishwashers, 2 of those you sponsor as H2bs, you have to treat the other 4 dishwashers with the same wage rate, the same promises and guarantees and working conditions as you did on your labor certification for those 2 H2bs. So if you have seasonal dishwasher cooks that you normally pay $18 an hour, as soon as the H2b show up and you're obligated to pay them $25, you have to pay all the U.S. workers doing the same job $25 an hour for the term of the H2b period. You must pay all corresponding workers the same wage and offer them the same working conditions as your H2bs. That includes if you, on that one night shift, that one night on Saturday night, you grab one of your U.S. dishwashers and you ask them to be a line cook, and you've sponsored H2bs for $25 an hour for line cooks, that dishwasher that you've asked to cook for that one night, you have to pay them $25 an hour. So the rules are there to protect U.S. workers at the work site. So if you bring in one H2b dishwasher, you've got to treat all dishwashers the same as that H2b for the entire period. And anyone that's doing dishwashing. It doesn't matter what you call them, all right? It's what they're actually doing at work. So that's the most important thing, is you've got to treat all workers in that H2b position the same, whether they're U.S. workers or H2b workers. Now, question always comes up, we have to treat J1s the same. There's nothing in the J1 regulations and there's nothing in wage and hour regulations that say you have to treat the J1s the same. However, you are going to commit discrimination by treating the J1 separately and differently. Okay, so if you bring the J1s in and your agreement is they're going to just do whatever you need as a restaurant or hotel for $18 an hour, but you have them doing dishwasher, or you have them as a line cook, and you have an H2b line cook at $25 an hour, you have to pay them $25 an hour, or I believe you will be subject to a discrimination lawsuit. All right, the rules say you have to treat U.S. workers the same as H2b workers doing the same job. But there's no rationale by which you can explain why you're going to pay J1s differently. Okay.
Now, can you, and we get this question frequently too, can you differentiate though based upon legitimate business reasons? For example, we have employers who will bring back the same seasonal worker year after year after year. So you might have a seasonal worker with 6 years of experience in the same job, and you might have a US worker who is their first time in the workplace. And you want to pay based upon experience. So you want to pay the person who's been here for 6 years $25 an hour, but your brand new workers $20 an hour. Is that legitimate?
No. Whatever your minimum requirements on your labor certification were. So most employers will say, cook, line cook, no experience necessary. And that's what you're paying. So if the prevailing wage comes back at $25 an hour and you agree, you sign your temporary labor cert, you bring an H2b in at $25 an hour, no experience necessary, then the fact that they have 6 years of experience and they've been with you for 6 straight years, you can pay them more than that. Okay, but the US worker that you asked to work one shift doing that job, you have to pay the same wage.
So the same wage as on the labor certification.
As on the labor certification. Unless you specifically said on the labor certification, all cooks must have 1 year of experience.
Right. So the US worker would have to make 25, but then you could have that worker who has 6 years of experience.
You can always
So
pay them
gotta
more.
pay them 30.
Correct. So bottom line is, if once you hire an H2b in a specific occupation, if you have anyone else doing that same job, even if it's for a shift, you've got to pay them the same wage you would the H2bs. Okay. Inbound travel and subsistence costs. Okay. Inbound travel costs. If you don't pre-arrange for it or advance the costs for your H2bs, that is, you have to pay all travel and subsistence once 50% of their employment for the season has been completed. So if they're working from April 1st until October 31st, whatever that 50 midpoint is, July 1st, by then you have to reimburse them if you haven't for all inbound travel and subsistence. Okay, so subsistence is the cost of meals and hotel if it took them 2 days to get from Florida to here or from California to your work site. Okay, and it's my reading of the regulations that if you hired a US worker from Colorado, you have to offer them the same thing. You have to pay for their inbound costs and their subsistence for the travel. Again, once you hire an H2b worker, you've got to treat everybody the same. Outbound travel costs. Technically, you are responsible. If they complete the certified period or you dismiss them early, you are responsible for their outbound travel. Okay, so if you terminate them mid-season, you have to pay for the reasonable cost of their transportation back to their home country or to the last place they worked before they came. The only time you're not responsible for outbound costs after your work is done is if they abscond, they just quit or they leave. Okay, if that's the case, then you're not obviously responsible for their outbound costs. Now, having said that, because employers of H2Bs are always responsible for their inbound costs, if your worker is going to another H2B employer, then it'll be the obligation of that employer next winter to pay for their inbound costs. Okay, almost done. All right, so this is a controversial part of the regulations, and DOL has not been funded, so Congress has not funded the Department of Labor, so they can't technically enforce it. However, I think that in the future, because you've got to apply, you're responsible for your H2b obligations for up to 3 years. So if Congress decides to fund the investigatory component of this, then you could be liable 3 years from now for what you do this summer. So the rule is that you must guarantee 3/4 of all the hours in every 12-week period. So that's not only for your H2B worker, but also for any US workers in the same position. So you have to guarantee to offer at least 3/4 of all the hours in a 12-week period. Okay, so 12 weeks at 35 hours at 0.75 is 315 hours in a 12-week period. All right, so you have to offer at least that, and you have to make up for that at the end of each 12-week period. Okay, What this prevents is they don't want employers to bring H2Bs up in and then bench them and put them in a non-pay status. All right, not that that's realistic in this economy and with the shortage of workers in the Cape, but basically what they don't want employers to do is bring H2Bs up and then not and only use them when they're busy. And the reason, the rationale behind this is really USCIS, is that if you don't give them enough hours, they're going to go work illegally for another employer. All right, so that's the rationale for that. All right, and the last obligation, which is a technical violation. I don't know if the Department of Labor would actually really fine you a lot for this, but the H2B earnings statement has to be very specific. It has to have the following information on it. Okay, it's not the ADP pay statement. It's not Paychex pay statement. The employee earnings statement for H2Bs has to have the employer's name and their FEIN on the paycheck. Has to have the the employer's name and FEIN on the pay statement. Employee's name and address must be on it. The employee's occupation must be on that pay statement. Beginning and end dates of the pay period, the hourly rate offered during that pay period, offers of employment offered per day. So you also have to track how many hours you offered. They may have declined it, but how many you offered. Hours actually worked in each work period, any itemized deductions and total earnings for the period. Okay, so that needs to be on their earnings statement every single pay period. You must retain that for up to 3 years. We talked about the 3-quarter guarantee. All right, you must pay all related visa costs. So if you have an employee that's coming in from overseas and they had visa costs at the embassy, and you have to pay for all those visa costs within the first week of employment. You also have to furnish all tools and equipment for the position. You have to, in theory, you're supposed to give the worker a copy of the entire job description with all the provisions and all the benefits that you're offering prior to them leaving to travel to your work site. So you're supposed to give them a copy of basically the labor certification showing exactly how much they're going to be paid and what all the terms and obligations are as an employer. There's also a poster, H2b poster notice that you're supposed to have up. We print it out. We tell our clients just to give it to each of the workers when they give them a copy of the job order. And then last is if the employment is terminated, whether the employee quits, takes off, or you terminate employment, you need to give Department of Labor notice within 2 days and USCIS notice as soon as possible. Okay, so those of you that participated in the H2b program or the seminar that we did last September, I try to talk employers out of it, right? Because I'm telling you right now, well, Nanci and I did an investigation together on the province now, and we actually got 0 fines on that. But my clients listen to me, and they have they literally get a compliance package that's this thick to record how they treat their H2B workers and all U.S. workers similarly. If your immigration attorneys are not doing that for you, or whoever you use for your H2B, I would ask them for a complete compliance package so you know how what your obligations and liabilities are. Okay. Again, the most important thing is you have to treat U.S. workers, and I think J1 workers, exactly the same as H2B workers if they're performing the same job duties, even if it's for 1 shift. Okay. All right. Are there any quick questions before I start?
I know we've got something in the chat. Can you check that out? Let us know. Are there any immigration questions?
Not yet. Can I interject since you're talking about, I know this is a common mistake that we've seen. We actually have a case on the Cape where they brought H employees over, but they called them something different. They were supposed to come over, say a housekeeper, but they actually did work as a cook. So they had, they were paying the lower rate, but you can't, you have to pay the higher rate, so we had to go in and take a look at what should a cook be paid?
Right.
That's a common mistake, or they're doing multiple jobs, so they have to be paid the job
Right.
that they're doing.
Right,
Rate.
and I think in the case that we had together, the only thing that they were found, that employee was found liable for was they brought in housekeepers. And they asked the housekeepers to set up the morning continental buffet. That's a different
Yes.
job,
Right.
all right? That's catering or that's prep cook. That's a different job at a different prevailing wage rate. So H2Bs, it's a very good point. H2Bs have to be, you have to employ them in the job you said you're going to employ them in. They cannot work in other jobs.
Or if they do work in another job when they come over, you have to pay them the higher rate, whatever, you know.
Yeah, but that's still a violation of the USCIS.
Yeah, but we would, if we
Right.
went, we would say, wait a minute, they're not doing, you know. So yes, it would be a violation, but we look at, what did you pay them? You
Right.
have to pay them the higher rate.
And Nancy, just to clarify, is that for just when they're performing that other job, or is that now for all hours worked?
No, when they would be performing
Performing
the
that
job, is that correct? Yeah.
So complying with H2B is not easy. And there's going to be a certain amount of liability and obligations if you're audited, because it's almost impossible to keep the H2B regulations completely straight. It really is. So that's just kind of the cost of doing business. But bottom line, treat everybody the same that's performing their job, and also they should only be doing what you said on your 9142. So if you brought them in as a cook at $25 an hour, that's all they should be doing. All right, so just read
I have
your
a question.
application.
You said, what exactly will cause an audit for a company? Do you
That's a good question. Do you want to answer that?
Yeah, we have, it varies from a complaint to initiatives to just a case assignment. And as an investigator, you're supposed to work all cases the same. An employer will always say, well, how come you're here? Did someone call and complain? And that's not always the issue. We're required to do so many H2B cases per year, H2A cases, so sometimes it's just by chance, but there are times when it is complaint-based, but we don't let the employer know that it's complaint-based. But I would say the majority is just random because we're required to do so many of those cases per year per district.
Right. And John and I we've been doing this for 25 years. I mean, in our experience, most of the complaints that aren't random are either generated by a disgruntled ex-employee or a competitor.
Right, exactly.
Yeah, I think a lot of employers don't realize that you know, employers, other employers or competitors who are playing by the rules are as likely to drop a dime as a disgruntled former employee.
We do look closely though at competitors' complaints because they're just calling to put the other company under the bus. And we usually want to verify it with an employee that's there, that there are violations before we would open a case, because obviously all competitors would just complain. Say, hey, go look at this company, and then they're stuck for months doing paperwork. And
Thank you, everyone.
Thank you.
That's it. Thanks a lot, Matt.
Take care. Great seeing you. I will.
We're going to talk about the investigative process some more, primarily Nancy and Tom will. They're going to speak right now. I'm going to talk a little bit about the Massachusetts Wage Act when they're done and fill in some gaps. But right now I'm going to hand it over to Nancy and Tom, and they're going to talk about compliance and federal wage and hour laws and other matters that employers should be aware of.
Thank you. All right, my name is Tom Carroll for people at home. I was previously an investigator with the Department of Labor for 12 years. I also worked for immigration for 17 years at USCIS, issuing green cards, citizenship, all those type of documents, etc. But just to comment on the H2B, it's very complicated because there's multiple agencies involved, which is a rarity. You have the immigration part, and then you have the Department of Labor part. So it's overwhelming to employers when they're filling out all these different forms. And that's why usually legal assistance is needed for those types of workers, because of the amount of paperwork that's needed by two agencies. One is bad enough, but the two, it's a lot of paperwork. But what we do at the Department of Labor Wage and Hour Division is we enforce the Fair Labor Standards Act. Try to look at the big picture because when you get a law book of regulations that's about 2 inches thick, and it's like all of this for minimum wage and overtime and child labor, but actually it breaks it down for all the different exemptions. And sorry, I'm speaking low. For all the different exemptions, there's all different, I don't know, it makes it very complicated, but to look at the big picture, we enforce minimum wage, overtime, child labor, record keeping. That's all under the Fair Labor Standards Act. Then we also have other acts where we look at Davis Bacon, which is government contracts. Whenever the government pays for a portion of any work that's done by any company, there's required prevailing wages and fringe benefits. Then we also do the Family and Medical Leave Act. The state also does that. It gets complicated because there's State Department of Labor and Federal Department of Labor, and usually an employer doesn't really know the difference between the two. A lot of it deals with the same topics, however, they do vary, and the employer has to comply with both state and federal regulations. I mean, the example is minimum wage. Federal minimum wage is only $7.25. No one's going to work for $7.25 in our area. And then the Massachusetts minimum wage is $14.25. So we say to the employer, you have to comply with minimum wage. They have to comply with both the federal minimum wage and the state. So whatever benefits the employee more is what they have to make sure they're in compliance. So obviously the minimum wage would be $14.25. It gets complicated for overtime because Massachusetts law has exemptions for certain industries that are exempt from overtime, and then it falls onto the federal law. Hospitality is the big type of establishments that is the difference because under state law, hospitality doesn't have to pay overtime at time and a half, but then it falls on us at federal. So usually if there's any type of complaint with the state will notify us and say, hey, we don't have jurisdiction on overtime. You're going to have to take this issue. So we always get the overtime issues for hospitality industry, which includes restaurants, hotels. The electronic versions of different fact sheets that were sent out to the people listening online, these Department of Labor has 100 fact sheets. So I kind of just picked the ones that I thought would be most important for the attendees of this meeting. The first one was just the basic information, is what I had stated. Just says that we enforce the Fair Labor Standards Act. Child labor is a big issue, and then Family and Medical Leave Act. Child labor is very important, not just by us enforcing it, but your education as an employer is very important, because say if you violated a child labor standard, you may have to pay a fine to us, $5,000 or something, which is a lot. However, if something happened to that child and it was a violation of labor law, that family is going to sue your company. I mean, for millions of dollars, you could actually lose your company. So for us being almost harassing you for like child labor, it's a good thing, because we really want to know your child labor laws, because definitely lawsuits would come of it if someone gets injured or hurt badly at your employment if you are employing them not illegally, but in violation of the child labor laws. So I just wanted to, I'm bouncing around here.
That's okay.
Yeah, so the next fact sheet was the tip regulations. Tip regulations are tricky. Every restaurant that we look at, there's usually a violation in overtime payments of tipped employees. The reason is that under federal law, the minimum wage for a tipped employee is $2.13. Again, no one's going to have that because the state requirement has changed every year. It's gone up, but right now it's $6.25. Is it $6.25?
$6.15.
$6.15.
So it's $6.15 an hour. They have to be paid by the employer, and then the rest of the minimum wages have to be paid by the customer, which is called a tip credit. So they have to equal $14.25 an hour for all hours worked as a tipped employee. Usually an employer will pay time and a half the tipped employee the hourly rate that they're paying them. So they say, okay, if they're getting $6.15 an hour, if they work overtime, I'm gonna pay time and a half $6.15, which would be $9.30 or whatever. That is not correct. And that's where it gets complicated. You're like, well, it's time and a half, but a tipped employee is a minimum wage employee. So they have to be making $14.25 an hour now in Massachusetts. So if they work overtime, they have to be paid $14.25 at time and a half as a tipped employee, which is, I
Well-
should be doing a little
well,
spreadsheet here.
And that's per shift.
Right, but then they still get the same tip credit for the hours worked. So if someone's, it's $14.25 minus what they're being paid is $6.15. So that's, so the company is taking an $8.10 tip credit for each hour worked by the tipped employee. So the customer is paying $8.10 and the employer is paying $6.15. However, if that tipped employee works overtime, then we say, okay, well, the minimum wage is $14.25. $14.25 times 1.5 is 21.38. So that individual has to be paid $21.38 an hour. However, the employer can use the same tip credit at $8.10 it did for the first 40 hours. So you can deduct that $8.10. So then the overtime rate would be $13.28.
can I,
Yep, go ahead.
I'll tell you something that's, see, because I'm a simple person.
Right.
So I always think of what's simple. So you have to just think of this. The minimum wage is $14.25. They have to get at least half of that. So you would pay $6.15 plus half of the full minimum wage, and let's see if it comes out to that. So what's that? Probably gonna come out to the same thing. So $6.15 plus $7.13 is $13.28. Comes out to the same, but you don't have to think, oh, what's the tip credit? I gotta, just remember, whatever the wage is, the tipped wage is, plus half of the full minimum wage, that's their overtime rate.
And the same as if someone gets $8 an hour.
Right.
They're a bartender or bussers usually get higher than the servers. The same thing, they have to be paid that extra half time, the minimum wage of $14.25, which is
$7.13. So they'd get $8 an hour or whatever their busser's rate plus half of the full minimum. That's their overtime. Or even if they got $12 an hour at some job, we'll just use this, they're, whatever they're doing. And they're a tipped employee, but I'm gonna, because, you know, I'm on the Cape and I gotta pay higher, I'm gonna pay $12 an hour, 12 plus half of the full minimum wage. So they would get 19 whatever an hour. Always remember that. If it's less than the full minimum wage, if you're paying them, even if you paid them 13, they still have to get half of the 14.25 an hour.
And majority of restaurants honestly don't know that. I mean, it's very complicated unless they have an attorney involved or.
Or a good payroll service
Yeah.
that knows what to do.
And the employer may always say, well, we don't pay them, ADP pays them, it's not our fault, they paid them time and a half, the $8. Well, no, you're responsible if you're not paying them
And
correctly.
most of the payroll systems still are not up to date.
Right.
Right.
The
It
shifts.
changes so
We
much.
have to do spreadsheets.
Sure.
Take it out of our, I can't think of the name of the software that was actually used inside the restaurant. And we would transfer it to a spreadsheet on each employee to make sure we were paying.
It gets
It was
complicated.
crazy.
yeah.
I
And
mean, 700
most of the
employees.
time, servers don't work over 40. It's kind of a rarity because they're usually, a shift is say 6 hours
Yep.
or, unless they do doubles and work every day, they'll go 40.
Question from the
Yes.
chat, I think you just answered, but is it asking over 40 hours in a week or anything over 8 hours in a day?
It's not, it's just 40 hours.
40 hours in a week.
It's not, the only time it's over 8 hours is if it's in the medical field, nurses, et cetera, that gets complicated, but in the hospitality industry, 40 hours, nothing about 8-hour days.
And it's not over, if you pay bi-weekly, it's not after 80. Every week stands alone. So if one week somebody works 50 hours, then the next week they work 30, it's technically 10 hours of overtime because they've worked more than 40 in a week. That's another common problem. A lot of people, oh, wait a minute, my payroll's, bi-weekly, I can pay overtime after 80. No, you can't.
And then I'll go into the child labor for anyone under age 18 that's working at restaurants.
Wait, before we do,
Yeah.
let me throw a wrench into this.
Yes.
One more complication.
Yes.
What if it's a slow night and the wait staff doesn't make much in tips?
Right.
They don't even make enough to bring their wage up to $14.25.
So the employee has to make an average of $14.25 an hour for all hours worked. Federal law states that that's at the end of the week that they have to be paid home.
Not anymore.
Right, but now the state
state law.
has
Oh,
it
the
by the
state.
day.
Yeah.
See,
So
we don't know that.
that's new,
Okay.
where
We
someone
need that.
works 8 hours and they only made, it was rainy and they only had 3 tables and they made $20 in tips. That didn't bring them above the average of $14.25. The employer has to pay whatever is needed to reach that $14.25 per hour per day now under state law. We don't
That all changed a couple of years ago with the grand bargain. And employers are responsible for making sure that their staff are paid at least $14.25 combined tips and wage for every shift per day, or if they work a double,
And that's a
every
big
day.
issue on the Cape. They are not getting paid because I have new employees come and they'd say, per shift? And I went, yes. So if you have a slow Monday night in May or June,
Yeah.
they need to pay you, up to minimum wage for that 8-hour shift. My daughter-in-law was continuously not paid for it.
And the same with training, when someone comes on the job and they're new, they conduct their training as a server and they're shadowing someone and they don't get tips because they're shadowing, they have to be paid the $14.25 for all hours worked. If they do get $10 from the waitress that's training them, you can deduct that, but they have to,
We just brought everybody up,
yeah,
just to minimum wage. And it was too much.
complicated.
Yeah.
Yeah, and then for tipped employees, no deductions can be made from your paycheck. You're considered a minimum wage employee. Most servers don't think they are because, I made an average of $30 an hour because it was a busy night with all my tips, et cetera. But an employer may sometimes say, well, your table walked out, it was $78, you're paying that $78. That can't happen because they're a minimum wage employee. On paper, because they're a tipped employee, they're minimum wage. They may make more some nights, but they're a minimum wage employee. No deductions can be made. It can't be for a walkout. It can't be for paying for uniforms. It can't be, no deductions can be made from a minimum wage employee because then it would be a violation of minimum wage.
The question is, should tips be reported after every shift or after every week?
Every shift, just because of the state requirement where they have to make an average of $14.25 an hour. That's new. It used to be after every week, after the full week, but it changed in the mass law. I don't know how current, a couple of years ago. or-
Yeah, the 2 years, 3 years now.
Right.
So regardless of how long the shift is?
Yes.
So that's the split
Minimum
shifts
wage
per
for
day.
all hours worked. Say if they work a split shift and they do 4 hours in the morning and then 4 hours at night, those 8 hours, they have to make an average of $14.25 for all 8 hours. For child or anyone under age 18 that's working at a restaurant, it varies into 2 categories. You have to be 14, 15, you have to be 14 years old to work legally under federal law. 14 and 15-year-olds have a restriction on the amount of hours worked and which hours they can work. 16 and 17-year-olds can work any hours, but both categories can't be involved in a hazardous occupation. That's kind of a general term, and my best advice is that if you have an employee and they're a pizza cook or they're a baker, call U.S. Department of Labor because we have a list of jobs that are considered prohibited or okay to work. it's very specific, it's very black and white, there's no gray area for child labor. So if you're concerned, and you're like, well, I'm not sure this person is gonna help cook pizzas, call us and we'll let you know, okay, are they 14 or 15, or are they 16 or 17? And then we'll let you know if it's a hazardous occupation or not.
You know, a lot of it is you can't use a meat slicer, obviously, if you're under 18. And a lot of them, you can't even use a trash compactor.
Yeah.
So that's a big one. People say, oh, they just throw the trash in. Well, you-
And again-
Walk-in freezers is.
Yeah, and again, it seems picky, but if a child is ever hurt, you know, you're gonna get sued by the parents, obviously, and say, why did you let my son or daughter use this? You shouldn't have allowed them, and it's a violation of the federal labor laws. So just really be careful on child labor. For the 14 and 15-year-olds, they can only work up to 18 hours a week during school, yep. And they can't work during school hours. So they can only work from 3 p.m. to 7 p.m. during weekdays, and then on weekends, they can work.
They can't work before 7 a.m.
Say until 9 p.m.
Not 7.
7:30.
7, but when they're in the summer, when they're out of school, it's still 7, but they can work up till 9 at night. They can't work more than 8 hours a day, and they can't work more than 40. So in the summer, they, once school gets out, they can work 40 hours a week, but they can't work past 9, they can't work before 7 a.m., and they can't work more than 8 hours a day. And again, I think Tom provided some info on child labor, but by all means, give us a call.
If they're 16 or 17, there's no restriction on hours worked.
Right.
You can work as many hours just like anyone that's over 18. Again, and then you have to look at hazardous occupations, so make sure that it's not an occupation where you have to get, it's common sense where if you receive a serious injury, like lose a hand or a finger on a meat slicer or a dough mixer that mixes the pizza dough, if you put your hand in there, you could lose your hand. So it's a lot of it's common sense. One of the big violations that I always see is delivery drivers. You have to be over 18 to be a delivery driver. It's considered a hazardous occupation because it's usually a timed delivery. So they're going to be rushing in their car and they're not seasoned driver. So that would be considered a hazardous occupation. I did put out one of the fact sheets on teen driving, but again, just be cognizant of that because if one of the delivery drivers gets in an accident, someone gets hurt or killed, the employer is going to be responsible. Yeah, well, it depends if it's
Yeah, if it's during
if
the
it's a
day,
delivery driver and it's a time pizza delivery.
Yeah. Limited. But this fact sheet that Tom has provided for child labor is excellent, because it really spells it out, so.
And I'll just add that you can get a lot of great information from the Department of Labor's website. There's great fact sheets on wage and hour compliance, child labor compliance, Family Medical Leave Act compliance. The Massachusetts Attorney General also has a lot of resources on their website. Again, mostly for wage and hour compliance, but also now they're responsible for paid family medical leave and in other statutes that they enforce. So there's great resources online. As Nancy and Tom indicated, you can always just pick up the phone and call them or call a compliance officer at their offices.
Our website is easy. It's just dol.gov, Department of Labor, dol.gov. And you're going to come up with our homepage. There's so much information, but it does have a search area as well. So if you want to just look up child labor or tipped employee or hours worked, you can put that in and it will bring up the regulations and the fact sheets with that material. I still use it all the time because you run into different scenarios that you haven't run into in the past. So the minimum wage and overtime we've discussed.
Can I
There
ask
are
about
exemptions.
overtime
Yep.
with commissions?
Sure.
Like some information on that.
Okay.
I've read it, it's really confusing.
Yeah, it's confusing. The best way to look at it, the
Because they're
easiest way
paid
is
after, and that's the issue.
right,
You have to go back.
to see what they made in that week. They're
Yeah.
paid 3 weeks later on their commission. It
That's
gets very
usually-
complicated.
That is,
Yeah.
Or quarterly.
quarterly commissions, yeah.
But what you would do is, best way to look at it is, for this week, how much did this person earn? With their commissions, with their hourly wages, how much did they earn? They earned, $863. Then you'd say, well, how many hours did they work? Then you'd say, oh, they worked 44 hours. So you would just divide the total amount of wages received by the total hours worked, and then you're gonna get that regular rate of pay for those 44 hours. So you owe, now you'll know, owe an additional halftime, whatever that rate is, for the 4 hours of overtime pay. But you have to be good in your record keeping because, again, like you stated, that it comes after the fact, where the commission comes in.
So Tom, as a practical matter, what would an employer who pays quarterly, maybe my commission plan is, I earn my commission when the customer actually pays the company. And sometimes it takes 60 or 90 days for the company to get paid. So I'm paid commissions on a quarterly basis. Do I look back 90 days to determine the overtime or minimum wage?
Yes,
Or overtime?
but let's say for the 13 weeks that were involved in that quarter, if the commission was, $5,000, you would divide $5,000 by the 13 weeks, and then you put that amount into the wages that were paid for each of those 13 weeks, and then you would have to pay an additional overtime pay if it was over 40 hours by determining how much they were paid by their wages, and now by that 1/13 of the commission.
Right.
And if there were overtime work weeks, overtime hours, if they worked 44 hours, you would say, okay, well, they made a total of what I paid them that week plus this commission. So their regular rate was that, those two numbers added together, divided by the total hours worked. So their rate of pay was $18.25 an hour and not 13 or 14, which I paid them at that time. So you may pay them below minimum wage at that time because they have their commission coming.
And what would be the ideal, if you're audited, what do you want to see?
We want to see that, yeah, we want to see, we're going to look at the payroll and it's going to say, okay, they worked 44 hours, they were paid, an average of $13 an hour. We'd say, oh, wait a minute.
Would it make sense to keep an electronic folder on that? I know the same people all the time.
Right.
So would it make sense?
You could, or, whatever makes sense to you, we will look at, if you say, oh, I'm gonna do it manually, I'm gonna have an Excel spreadsheet for each person.
Yeah.
Fine. And it's only for overtime work weeks.
Yeah.
If they didn't work any overtime,
Doesn't
say,
matter,
say there's 13 weeks and only 3 of the weeks they worked
most of them are
overtime.
salary.
So are they exempt employees?
They're exempt.
Then we don't care.
But I have a couple that are.
Yeah.
But even if they're on commissions, you still have, you're bound to pay them all their wages when they're due. So, we suggest a very clear written commission policy. And employers in Massachusetts can, you don't have to pay commissions as long as the person gets minimum wage and you meet your overtime requirements. And because an employer is not required to pay commissions in Massachusetts, you get to define the plan. So you can make commissions payable when the customer pays. You can set guidelines for how long, if at all, after the employee leaves employment, commissions are going to pay. You can have a policy that says you don't get paid regardless after the commissions after the day of your separation from employment. So you get to set the rules, but the clearer your rules on commissions, the less trouble you're going to have down the line. Because again, what the DOL wants to see, what the Attorney General wants to see is, do you have this documented? Do you have pay documented? And does it all add up? So your compliance, the burden is always on the employer in Massachusetts to be able to demonstrate that you've complied with the law. And you can have an employee who complains to DOL or the Attorney General that, gee, I didn't get paid, and they may not have the documents, this may be verbal. And if you don't have the backup, if you don't have the documentation, the governing authorities are gonna accept the word of the employee because you violated law by not keeping the proper records. Sorry.
Yeah,
No,
I mean.
No, that's all right, I try to,
I know.
they're monthly, so what I try to do is pay them the first Friday after the end of the month.
Right.
But is it written anywhere? No, I'm gonna go back and write it up.
right. No, it sounds to me like what you're doing is right.
And again, as from the Department of Labor, we're not out to say, oh, we're out to get you.
Yeah.
We're out to educate, to make
Mhm.
sure that you
Yeah.
don't, get kicked later on and say, oh, no, I didn't do this correctly for the last 4 years. And, but we deal with all different ranges of employers. I mean, if it's willfulness regarding like, some companies are really sketchy, everything's paid in cash, and it's awful. And then the employers that try to do the right thing, we realize that, and I want to say we back down a little, but we kind of do, because we say, no, you have to do it this way. You're doing everything properly. However, you got to change this because you're not doing that right with your commissions. You're not paying that overtime for that extra commission money. So, what was that? So one other issue, I'm sticking to restaurants. I don't know who else is representing, but if someone works multiple jobs at a restaurant, if they're a server for 3 shifts, and then they're a hostess for 2 shifts, and then if they do work overtime, there's 2 different ways that it can be addressed. If you're organized and you say, okay, once they hit 40 hours, whatever job they do after 40 hours, then I'm going to do that rate and that rate of overtime. But the majority of time, that's too complicated. So what we say is, okay, well, at the end of the week, we do a weighted average, meaning that how much did you receive total for all your positions? The server, you're going to be $14.25 an hour. And then if you're the hostess and you're getting $18 an hour because you're not getting tips, then how much did you receive for both positions? And we'd say, okay, I worked a total of 50 hours and I got $700. You say, okay, I'm going to divide the 700 by the 50, and then that's my regular rate. It's a weighted average rate. It's going to be not going to be $14.25. It's not going to be 18. It might be $16.50. So you would pay the overtime on the $16.50, a half of that, $16.50 for any hours worked.
We always did a blended rate, I called it, and we had a really fabulous
Yeah, and that's,
spreadsheet, if anybody, I mean, it's really easy, if
Yeah.
anybody would like it, I'd be happy to share it. We don't have tipped employees anymore.
Is that new? I was always under the impression before when they were just different rates.
Yeah.
The overtime was always had to be paid at the higher rate.
at the position that they're in. If you, it can be no.
I mean, that's okay if you did do that, that
Yeah, but I from a business
Right.
standpoint, I prefer not to, but
No, you
I was
could
always-
pay it one of 2 ways, like Tom said, a blended rate,
Right.
or the rate in which it's worked. So at the beginning of the week, say them, if you can track it,
Yeah,
they're
I've seen
paid
a lot of
18.
us to do that really easy, so.
they're paid $18 an hour. At the end of the week, they're a waiter. And their overtime was on a wait shift. You can pay it on a wait shift, but it has to be consistent. So a lot of times what we'll see is, oh, they always paid it at the lower rate. Now, you always paid it at the higher rate,
Yeah.
which is fine, but you don't have to do that.
You just confused me.
Wow.
You just said if they started out as a host at whatever higher rate, the end of the week, they waitress, you would pay them on a lower rate?
You could-
If they wait over the 40 hours.
If their overtime occurred when they were a wait staff person,
I never was told that. I always did the blended rate. You know what?
you did the right thing. You did the right
It's
thing.
very complicated.
But
Then you're
you
saying-
can do that. It's complicated though, because you gotta follow, okay, wait a minute, when did they work overtime? What were they doing when they worked overtime? Versus what you
Sometimes
said
they have
is,
3 jobs, so.
right,
Yeah,
it's
I just did the
complicated,
blended
right?
rate.
No, you did the right
Yeah.
thing.
But if you're exact on your records, you would be,
No, most payroll system, I mean, it's.
Yeah. once it hits over 40,
It's
whatever
similar.
job they're doing,
That's
they-
child's play.
you can.
Right.
Yeah. I mean, now, especially everything's electronic.
Right, that's what I
Talking
mean.
before when it was more difficult. but-
Question from the chat, can you pay tipped employees an hourly rate that is above minimum wage, since they're very experienced, and then entry-level employees at the 6.25 minimum wage tips?
Yes. Although all tips are the employees' tips. So that $14.25 an hour, they have to get their tips as well. Let's see. Okay, record keeping requirements. That's another thing we look at all the time. We just have to have good records. That's what we go by when we conduct our audit. We say, oh, we want to see your time records and your payroll records for the last 2 years. We can go up to 3 years. I didn't address that, but we have jurisdictions to go back 2 years for a company. We can't go back. Someone say, oh, I've worked at this company for 7 years. I want all my overtime for the last 7 years. I'm sorry, we don't have jurisdiction. We can only go back 2 years. If we can prove this willfulness on the employer, meaning that the employer knowingly violated one of our regulations, then we can go back 3 years and look at 3 years of time records and payroll records. A lot of times, smaller companies don't keep good time records. I mean, everything now with Toast and all these different apps or that restaurants use, it's a lot better now, but some of the smaller companies don't have that. They'll even sometimes still have, they'll make a punch in, or they'll even keep a written record. That's fine as well. We don't say you have to have, electronic versions. It just makes it a lot easier for the employer. But as long as you keep a record of their hours worked, so I can say, okay, July of last year, I want to see week of June 13th, who worked, how many hours, and what were they paid. They have to have that. A lot of times employers that are new will say, oh, I didn't save it, I threw it away, I have payroll, but I don't have time records. So that's when we can reconstruct hours worked for employees. We would do interviews of employees and ask them, how many hours did they work on average, or they may keep a book themselves of their hours worked, but it gets a little gray because if the employer doesn't have a record of hours worked, what we do is we interview multiple employees and we get an average of hours worked for the employees, and we'll do that. We don't want to say, okay, well, this person, Mike Smith, told us he worked an average of 45 hours a week. This person, Jane Doe, said she works 55 hours a week. We don't want to say, okay, it's just based on their statement, and the employer is going to know how did they get that information. That the employee must have told them that specific information. So in order to protect the employee, we say, okay, of the employees we spoke to, we got an average that your employees worked 46 hours a week on average, and you don't have any time records. So we kind of have to go with what the employee is stating. We sometimes go by and say, did you keep a schedule or work, schedule weekly schedules? And they'll say, oh, I have those. Then we can use those, where it's just a schedule that they post in the restaurant, who's working what days, what shifts, and we'll use that as their time records.
Let me just say, we always tell employers, it's to your benefit to keep good records. It's to your benefit.
And how many years of payroll records need to be kept?
3 years for wage and hour, but then there's IRS, there's all different agencies. Under wage and hour, it's 3 years.
We suggest, Tocci and Lee has always suggested that employers keep records for 6 years, post-employment. And, now with the ability to scan and keep records electronically, there's no law that says you have to have paper personnel records or paper payroll records. So you can keep these records electronically after an employee leaves. But because we've had cases in which employees have come back and said, all right, I worked there for 10 years and I think I got ripped off in my overtime or some kind of pay matter. As Tom said, under federal law, they can only go back 2 years. That's a statute of limitations for wage violations. State law, it's 3 years under the Massachusetts Wage Act. But they can still go after you for breach of contract, which is 6 years. And we see that all the time, where a person will file a complaint against a client and they'll have Massachusetts Wage Act claim or a federal claim, and then they'll always have a breach of contract claim and try to go back the extra time. Those are tough claims to make sometimes, but because of that, we recommend holding on to records for 6 years.
Okay, another topic is hours worked. What are hours worked? In a restaurant, there's a lot of downtime between lunch and dinner, or where the employer will say, well, they were on break for those 2 hours, they didn't, they weren't working, so I'm not paying for those 2 hours. If the employee is required to stay on site or in the parking lot and they can't leave the area, they're required to be paid for those hours. Those are considered hours worked. A lot of times servers or people in restaurants, they'll do a lot of their side work when it's slow, roll-ups or, stocking different things, but hours worked is when you're not free to use the time on your own to do whatever you want. I know it's usually on call, is not used in the restaurant industry if someone's on call, but if someone says, okay, you're on call this weekend, we might need you if the restaurant gets busy, you don't have to pay anyone that's on call. They're not actually working. If they're told, okay, stay within a 10-mile radius in case we call you to come in, that's, they still have free movement. They can go shopping, they can go to stores, etc. They don't have to be paid. Once they're called and they have to come in, they're on the clock as soon as they're called to come in.
So would you also say that once they're also restricted to a place?
Yes.
Like if they're told, you don't have to come into work, but you have to be home
Right.
for these 2 days on the weekend. They can't leave
No.
their home.
Home, it's home.
You'd say it's not hours
It's
work.
not
It's not hours work,
It's not
Well-
even if they're confined to home.
Yeah.
I mean, do they, well, nowadays with cell phones, nobody's confined.
Yeah,
That,
that's
we
true.
don't see that
Doesn't
anymore, I
happen.
think,
Yeah.
But if
It's on site.
it's on, like if they're home, or if they're home and they get a phone call, they've got to answer that phone call, that's all hours work,
That's working time.
right? That's working time. Or at the end of the shift, if the employer, we see this punch out and go back and do your side work, you can't do that. I mean, oh geez, I had everybody punch out so they're not on the clock. No, they're still technically working because they went back and they did the job. So,
And one thing we've seen over the past 10 years with the rise in social media, and you've probably seen it too, is after a shift ends, an hourly worker, if the hourly worker is directed or strongly suggested to get on social media to talk about what a wonderful place it is to work,
Really?
or things that we did today at the workplace and accomplished today, if that's a requirement and they're getting online after work,
interesting. Yeah.
then they've got to be paid for that time. So, often we suggest having a strong social media policy, just clarifying that if a person is going to post on social media, they're doing it on their own time, even if they are talking about, the workplace. That's their own time.
We get a lot of complaints on call. Someone will say, okay, they told me to be on call this weekend. I can't drink. Like, what if I want to go to a bar and have a few beers or this or that? They'll be like, well, I've been drinking, I can't go to work. If an employer calls you and say, okay, we need you to come in, and you explain to the employer, well, I've been drinking, the employer is most likely going to say, okay, well, don't come in. But they can use it against you, like, for discipline, but they can't do anything about any violations regarding the labor law. Say if they call this person every weekend and they always have an excuse, they can just terminate them. That's up to the employer. But if they're on call, they don't have to be paid. So, the whole thing with accurate time, like punching in early, doing work before you punch in and doing work after you punch out. We see that a lot in hotels and motels with the housekeeping or cleaning staff. If that's the case, if you're involved in hotels or motels, sometimes that company will hire a third-party agency for their housekeepers, that is called, it's their own entity, and they'll hire that company for the housekeepers. You have to remember that you're a joint employer of that individual, so if there are violations, you'd be liable as well. We get a lot of complaints where housekeeping, they're usually assigned, you have to do 12 rooms and your shift is from 9 a.m. to 3 p.m. They'll punch in at 9, they'll start their work, and then 3 o'clock, oh, they didn't finish 2 of their rooms. The employer will make them punch out and then finish the 2 rooms they didn't do, and they don't get paid that extra hour. if the hotel that doesn't know about that or doesn't check up on that, they're partly liable because they're a joint employer of those workers. So let's say, oh, it's a temp agency, they violated the law, we didn't do it, but they're a joint employer, so they could be liable as well. So they should just check in with their employees and say, hey, are you paid for all hours worked? Are you getting overtime? Are you getting minimum wage? So if there are issues, they don't want to learn about it 2 years later and then get stuck paying half the bill of back wages for employees that weren't paid properly. But yeah, just anytime you're conducting work before a shift starts or after a shift, but before you punch in and out, that's hours worked. We get a lot of complaints about that as well, especially at the end of the shift where someone punches out and then, oh, you have to now clean the restrooms and, do some additional work. Let me see. There's no questions for the people watching on the topics that
We
we've
have
had?
2 questions still related, I think, to H2b that came up
H2b.
before. I can fill those out. So one is there a penalty for an employer who hires an H2b worker and they are not the employer, the H2b employee the worker has a contract with? So like the second job, for example, if someone wanted to pick it up with you. Is there a penalty for the employer who hires that person?
Well, that's not, I think that's a violation of the law. How much the penalty is going to be is a question. It does happen a
It's
lot.
both a
Some-
violation of immigration and labor,
Yeah.
both agencies, but there would be, we can do civil money penalties and it depends on the whole scenario.
Tom, what would be the proper process? If someone comes over here and say the company goes out of business or they get terminated, they're here on an H-1B
Right.
and someone else wants to hire them for the rest of the season.
They-
How do you transfer? Can you transfer?
Yeah, I mean, you could file, they'd still be an H-1B, but you would have to file new paperwork to go from an H-1B to a new H-1B.
Right.
The new employer. You can't work on that previous H-1B with a different employer, it'd be violation.
But it's because we're talking about seasonal workers
Right.
and the time it takes to process H-1Bs, it's never going to be, it's going to
Yeah, I
take
know.
months and months to
I
process.
know,
So what it means is the subsequent employer is got to take the chance that, and if the employee has filed to transfer the H-1B, it's going to look better than if no paperwork was ever filed and they just started working for another employer. I think and you tell me, you're the enforcement agency, I think though the DOL would look more kindly, maybe, on an employee or an employer that tried to do the paperwork correctly.
I had this with Matt, actually, in P-Town, where there were numerous employees who worked for this one employer, but then at night, they did another job. I'm just saying, we didn't go to those other employers that they worked for. I mean, should we have? I don't know, but they were all, it seemed like, having second jobs.
So someone in the chat has said there might be an exclusionary penalty for that employer. They would not be allowed to have the visa employees.
Yeah,
for a
and
certain
we could
amount of
notify
time.
CIS or even
Could.
ETA, say, okay, this person, this company violated the law, don't approve any petitions that they submit in the future.
So is it at the discretion of whoever's doing that investigation?
Yes,
As a practical matter though, a first-time violator is not likely to be.
yeah, if there's a history of it,
There's a history.
you would notify
Like
them,
anything else.
first time around, slap on the wrist, but if it happens again, now they have a history, and because of a history, that's when you have civil money penalties besides being barred.
And then the other question I had, I'll read it verbatim. Do you have I-9 assistance, as we are seeing that there are a mix of allowable documents?
We no longer look at the I-9.
No, we don't look at the
That's all
I-9s, we used to. I didn't realize that it's different. It was always, the first column, if you have one from A, I used to say that's all you need. If you don't have one from A, which is like a passport or a immigration card, you've got to have a driver's license and a birth certificate. I don't really know what,
We previously asked for copies of I-9s.
we don't.
We don't any longer. That would be a violation of immigration law as opposed to Department of Labor.
And the I-9 itself has the list
Right,
the full I-9 form.
right.
So if someone is showing you a document that's not on that list, either you're not going to accept it, or you might call it the CIS, Citizenship and Immigration Services, for more information and clarification, because those lists are pretty exhaustive.
You can accept an application, like for J1s, they have 2 weeks to get their social security card, so I would actually get the application, and sometimes even a visa, because they're so behind, it's
Oh,
crazy.
sure.
I have a woman from, UK, and she's still waiting, but we have a letter from the attorney and the agency from ICE saying they've accepted it, they just aren't about.
Okay.
So, but no, I would be so careful, because I think everybody's going to be audited on I-9s eventually.
And
I would be very careful with what I collect for
I mean,
documents.
the amount of employers that we audit is like, we always say, like a dot in the sun. It's just a small portion of the employers, so it's highly unlikely that you do get audited, but again, it's just depends on disgruntled employees, usually someone that's left the company that, oh, I was there 15 years and they loved their job, they loved the owner, all of a sudden, something
Something
happens.
happens and they're done.
They throw the employer right under the bus, knowing if I can get any money, I'm gonna get what I can get.
Well, if you accept, or if you accept 2 forms of identification and they just put their US citizen, and all of a sudden you find out, oh my God, they're not a US citizen. You do, so I don't know, I go overboard, I go to the I-94, I just check to see when they came in the country,
I don't know, is
Make
immigration
sure.
out there checking,
I
or
know,
it's find that hard
It's
to
difficult
believe,
if
but-
someone puts they say, okay, I'm a US citizen, they just make up a social security number. They're good for that year.
Mhm.
It's at the end of that year when the real person is notified, hey, you made 32,000 at this restaurant. And you're like, I never worked at this restaurant. And that's when,
Do you require physical, copies of it? Take a social security card, because I've been told both, some people say,
You
don't
have to
keep the
all
copy
or
because,
none.
right,
Yeah.
okay.
So if you keep copies of ID for everyone,
Yep.
not just who you suspect. You're not taking.
Yeah.
Yeah, and the last thing I want to mention is bonuses, how it relates to restaurants. We've seen a change recently where employers are putting a 3% gratuity on their menu, and it says, oh, you're going to have a 3% gratuity charge that's going to be paid to the back of the house for the cooks. Because the front of the house is getting a high amount of tips, the back of the house usually makes less. So if that 3%, you have to include that in their regular rate of pay. So if the back of the house, the kitchen workers work over 40, you got to include that 3% for that week as wages, so that if they do work overtime, it would affect their overtime rate a little bit, maybe 50 cents or whatever for overtime hours. And one last thing I want to say is back of the house employees at a restaurant, majority aren't exempt from overtime. If you have the chef or who's the manager in the kitchen, they're exempt from minimum wage and
as long
overtime.
as they're paid a guaranteed salary,
However,
and
if-
they supervise.
yeah, but say like line cooks, prep cooks, all that, if they're paid a salary of $1,000 a week and they work 40 hours, that's fine. If they get $1,000 and they get 50 hours, you would do 1,000 divided by 50, is $20 an hour. They'd do an extra $10 an hour for those 10 hours of overtime.
And you have to keep track of their hours for those people.
It's just complicated, and if you do have questions with Google and everything, with DOL.gov, if you take the time, it's all there. Sometimes it's frustrating to find it, but on DOL.gov, if you put in the search button, very specific, you're gonna find a fact sheet, you're gonna find the regulations and read up. And if it's still confusing, you can always call us. We have someone that answers the phone every day,
Yeah.
8 to 4:30. If we don't answer and you leave a message, someone will return your call by the next day. And the phone number is 866-US
No idea.
for wages.
You have no idea.
I know, it's right here.
I-
But and then you put in your zip code, and then you get transferred to the Boston office or whatever office you're calling from. 866. What is it?
I never called it.
866. The number.
866-487-9243.
Oh, it's 4 US wage.
Oh, is that
The
it?
number 4?
Yeah, 4.
For
US
USA?
87 US wage.
Well, thanks so much. Really appreciate it, Tom and Nancy. It's great to be here again. I'm going to fill in some gaps and talk a little bit about the Massachusetts Wage Act. All employers in Massachusetts have to comply with both federal and state law. And under state law, it primarily means the Massachusetts Wage Act, which is it's a very tough and unforgiving law. Now, where there's overlap, and there's significant overlap in federal and state law, the law that's most beneficial to the employee governs it. That's why under Massachusetts law, for example, there's a lot of exempted industries and businesses from overtime law. Hotels, restaurants, but under federal law, you've got to pay overtime. So it doesn't matter. You've got to pay overtime anyway. So you'll have the state law minimum wage, but the overtime law of the federal government applies. We put together we tried to have a very comprehensive or pretty comprehensive cheat sheet, which I think anyone who's signed up will get. The folks in this room have it. We don't have to put it up, but I'm going to go over a few of the things that are in there as well. If we have any retail establishments here, you may all be aware of the Sunday pay law under the grand bargain of a few years ago, in which minimum wage was slowly increased. One of the bones they threw to employers was slowly eliminating the Sunday premium pay law, which now is 1.1 times overtime. I believe it's 1.1 now. It's 1.1. So for a retail employer who employs employees on a Sunday, used to be time and a half, just like overtime. And over the past 4 years, it's been slowly reduced to 1.1. And as of January 1st, 2023, Massachusetts will have no more Sunday premium pay. You should be mindful of the Massachusetts tip statute. I know you all are. It's a little bit different than the federal tipping law, but one of the biggest areas of confusion we see is number one, control of the tips. Management should have as little control over the tips as possible. Right? Management can't participate in distribution, it can't participate in the tip pool. But I think as far as management can go is in helping to distribute the tips. So we can help our employees figure out the best way for tipping, for distribution if it's a tip pool.
I'm sorry. Does that mean we, with regard to servers and stuff like that, can you specify, can our house specify the dollar percentage that has to go to a subsequent employee, like the bar tips out of bar back, and it's going to be specific, or the servers tip out the bar? Can the restaurant say it's got to be 5%, or can we make that recommendation, or does it have to be a recommendation?
Yeah, it's a
No, it could be a recommendation. We say it really shouldn't be more than used to be like 20% or something.
Oh,
between.
yeah, no.
but no,
But-
we're talking about, but.
No, tipping out, right? Tipping out.
Under Massachusetts law, though, the employer is not supposed to dictate the policy.
So
Generally, either.
a server could say, listen, I'm not going to tip anybody out.
Right,
Well-
right. But you know that doesn't happen.
Right, exactly.
You
No, I
can
know.
say,
Yeah.
you know, we recommend this, but that's up to you.
And the employees typically will get together and help management figure out at
Right.
the outset of the season or when the establishment opens, this is what our tip pooling agreement is going to be. And everyone on board, yeah, everyone's on board, and now you have the agreement. And if someone comes in, they can be made to comply with the agreement because you're not dictating it.
Right.
All the other employees have agreed to this. Now, the question is, can you terminate them if they, refuse to participate? No, if they refuse to accept it, perhaps they don't get tipped as long as they get minimum wage. That's,
The bartender's not gonna help them too much.
Right, exactly.
They know
Yeah,
that,
then it
right?
hurts the business though.
Yeah.
But the definition of wait staff is very clear in the tip law. It's a person, waiter, waitress, bus person, counter staff who serves beverages or prepared food directly to the patrons. Someone who clears the patrons' tables. They have to work in a restaurant, a banquet facility, or other place where prepared foods and beverages are served, and they have to have no managerial experience. So again, we get into the issue of, well, what happens if I have someone covering a supervisory shift? They're managing the restaurant a couple days a week. Well, for those days when they're covering the restaurant, they're not working the counters, so they're not working directly with customers. Well, you can pay them as a different rate as a management employee. They've got to get at least minimum wage, 14.25. But they can't be tipped out if they're managing. You only get tipped out if you're working directly with customers.
No, you get to use substitute.
So, the service bartender is a bartender who prepares the drinks, even if they don't serve directly. They're preparing the drinks that are then brought to a table. So that counts as a tip staff as well. One of the problems, at least early on with the tip law when it passed some 15 or so years ago, is clearly communicating to customers when you have a service charge, whether that is a service charge that goes to the house, or is it a tip? Like, a lot of places just automatically, even if it's, fewer than 8 people at a table or 6 people, will tack on a service charge of 18–16%. But customers have to know, it should be clear for staff and customers that this is a management fee or a service charge, which means it's going to management. It should clearly state if it's going to staff, this is a gratuity, okay, 18%, 16%, whatever percent gratuity. So the customer knows if they're tipping above and beyond, and it's clear to Department of Labor when they come in that, this is a gratuity. This all went to the staff as part of their wages, and we avoid the problem.
Can I?
Yep.
This question is specific to a head bartender. If you pay him a salary, can he get tipped out by the servers?
Yes, and
Yeah.
in all likelihood, the question, and we could have a whole seminar on exempt and non-exempt.
Right.
A bartender is non-exempt, right? So meaning you can pay them a salary, but you also have to pay them overtime. They're not exempt from overtime laws.
Right, no, I get that.
Yeah. So when you calculate overtime, they can get tipped out because they're a direct, under Massachusetts law, they're a server under the definition of a server. So if they're serving people at a bar or they're preparing drinks that wait staff then bring over to customers, they fit the definition of a server under the tip statute.
Even though they have management control over that?
Usually it's like they're a dual
Right.
role where they're managing and they're also serving. So
Correct.
since they're serving, they're considered a tipped employee.
Right. Like sometimes in very busy bars, we'll have, like the chief bartender who manages the bar, and you might have 2 other bartenders in a bar back all working behind the bar, or there's some bars that are huge. You just see 4, 5, 6 people behind the bar sometimes. And yeah, if they're serving the customers, then they are a server.
It's consider like we see a lot of like foremen on construction. They're the boss of everyone there, but they're also working there.
Right.
They're not exempt from. They wouldn't be exempt from overtime because they're actually working, even though they're a supervisor. But they're also working.
Okay.
Because a lot of bartenders, I think, will be paid a guaranteed salary, but they're behind the bar. And yeah, they might do the scheduling for everybody, and maybe they are exempt, but they are serving, so they should retain those tips.
Yeah, my concern wasn't the overtime compensation.
No, it was the tips.
Management, yeah.
They can receive those
Right,
tips.
okay.
On pages 3 and 4 of our handout, we've tried to list all records that must be kept for non-exempt employees and for other employees as well, for exempt employees. It's, you can take a look at that. I'm not going to go over it. But again, we see the biggest problems we tend to see are not only when there are violations, but when the employer has poor record keeping. And they can't demonstrate that, yeah, we gave everyone a 45-minute or a half hour or an hour-long lunch break, and they were free to leave, and your employees may be saying otherwise. But if you have time records and time cards and make people card in and out, then you're going to be in a much better position. We have a number of cases that we've dealt with through the years are employers who initially were helping out an employee, paying a little bit under the table so the employee still qualifies for Mass Health, just paying in different ways. They might pay them a weekly paycheck for 40 hours and then the rest in cash, doesn't get reported. In all likelihood, they're going to get away with it for a little bit. But if the relationship sours, that's when we see this all the time. The relationship sours, the employee takes off and gets a lawyer and files a wage claim. And you're on the hook because you don't have the records to show that, yeah, I did pay them under the table. It might be a violation of tax laws,
But you paid them.
but if you paid them, DOL is going to be satisfied, the Attorney General is going to be satisfied. But if you have an employee saying, no, I never got paid under the table, what's he talking about? He's lying. If you don't have the records to back it up, they're going to believe the employee. I have a client right now. There's an allegation that the employee was never paid any wages, just got tipped for 4 years, just kept tips.
Could
And,
happen.
That's
Could
good.
happen.
There's a little immigration thing mixed
Yeah,
in
yeah,
this,
could happen,
a little
sure,
coercion,
sure,
but
sure.
it's not a good situation. The employee has no records whatsoever of this employee even working there. Never, no I-9, nothing. And that's big trouble for the employer.
And what happens is, say, if we have cases where servers or bartenders just say, oh, I'll work for tips. It's good enough that my $3 or $6 an hour, I don't care about it. I don't even.
And there are places where, they'll take
Absolutely.
a few $100s a shift.
Because
They're like,
that
that's
little
fine.
bit is nothing
Saturday
to
night,
them.
it's
And
Friday
then
night.
they get in an argument with their employer.
Yeah.
And they say, I quit, whatever. Okay, so now they'll call us and say, hey, I was never paid. I only received tips. We say, oh, really? How long did you work there? How many hours?
Yeah.
Then the employer has to pay minimum wage because they didn't use the tip credit. They pay minimum wage for all hours worked over the last 2 years. And you get stuck with like a $30,000 bill for the disgruntled employee that you were doing a favor for, or, it always comes back to bite you.
Under
Employees'
federal
eyes,
law,
yeah.
and we'll talk about the
Yeah.
Mass Wage Act in a second.
But I mean, employees, it's so different now that employees, it's my right, this is my, it's, you're working for this employer, it's their business, it's their, but the employee states like, well, no, it's my time, like, it changes like that. So you just want to make sure that you have everything in order, because once a disgruntled employee calls us, we have to reply, and then the employee gets really hurt.
In the Attorney General, again, when they audit someone, if there are record-keeping violations, we almost always see fines. They're usually minimal, but there are almost always fines. It might be $250,000, $500,000, depending on how serious. But you're going to avoid that problem by just keeping really good records. And again, they can be digital. In this day and age, that might be the way to go. And there are companies that will digitize all your records as well.
I just want one thing on records, date of birth for anyone under age 19. You need that. You're going to say, oh, this kid told me he's 19. He told me he's 19. He lied.
Yeah.
Anyone that's 19 or under, get proof of date of birth, so that you're covered. So if something does happen, you can say, well, he said his date of birth that he gave me. Say he gave you a fake card or a fake ID. At least you have the date of birth that he claimed that he was.
And just a reminder to be careful with the Massachusetts data security law, which if you've got an employee's, a social security number on a form, or a visa number, sometimes employees will give you a copy of a canceled check so they can have direct deposit, and that's in their personnel file. That needs to be very strictly safeguarded. Lock and key if they're paper, password protected with limited access for personnel records if they're electronic. Okay. Posting of notices, again, nobody has to pay for notices, the Department of Labor and the Attorney General. You can get notices through them, but of course it's probably pretty simple to get, and we do it too. You just get the all-in-one posters, state and federal. It's worth the price, at least in my experience.
Does everybody know about the tip line? I use it all the time.
The what?
The Attorney General's tip line, just for,
Well, good,
you
yeah.
can call anonymously.
Yeah.
If you have, quick question, and they're fabulous, and
Right.
I've used them a bunch of times because we have so many different businesses, it's confusing. and
Yeah.
stuff.
Yeah.
Especially the holidays,
Yeah.
and we have a pro shop, and, there's 3 holidays you had to pay them time and a half, that was
Right.
it, it's just very confusing.
Right.
So if anybody out there, if the number's right there, just put it in, I mean, I have it on my desktop. Attorney
Get on
General's-
speed dial?
No, on my cell phone.
Yeah.
Especially through COVID, we had a bunch of different questions, and
Yeah.
I actually have this fabulous attorney, and I said, so what was your position? He said, oh, I do all the investigations.
Who was it? Do you know?
I don't remember
Not
his name,
Greg.
but he was wonderful.
Rutland, yeah.
I mean, it was 2020, and
Yeah.
they were, we were bringing people back, and we did a kind of a creative thing, and I said, can we do this? And he said, yeah, actually, that's a really, admirable thing to do to keep your employees employed, and
Yeah.
so anybody that wants to use that, call me.
And there has been a bit of a change that I've sensed over the last few years. There was about 10, 12 years ago, there's a famous report called the Weil Report. He eventually became the labor
After a while.
secretary, right?
Yeah.
Wow. And he wrote this very long report. He was a professor at BU at the time, and he suggested to governing authorities, and this is when the economy had tanked in 2009 or so, 2008, that to get more bang for the buck, no negotiations with employers, and be tough on employers. For a number of years, we found that that's exactly what was happening. The AG was no longer giving us breaks, no longer really negotiating things with us. Very, very tough. And I've seen it change. I think in part wrought by COVID. I think there's a better understanding of what businesses go through. And the best thing you can do, even if you're in violation of the law, is be able to at least demonstrate that you were trying hard to comply with the law. You thought you had all your ducks in a row. You want to make sure everyone's paid correctly. And in these days, I think you're much more likely not to get leniency, but to get understanding from the Attorney General or the Department of Labor or other governing authorities. I think this is, there's almost a sense of sympathy and empathy from, because it's weird to say about an enforcement agency, but they understand particularly what the hospitality industry has been through over the past few years. And I think they're bringing that understanding to the table now, at least in my view, the audits that I've been working on the past couple of years.
Common sense,
Yeah. I'm not going to really go into exemptions. That's a whole seminar in and of itself. The Massachusetts paid sick law is a seminar in and of itself, but under Massachusetts law, you've got to pay your employees 1 hour of sick leave for every 30 hours worked. Just quickly, the mistake I see most often is that the employer doesn't pay sick leave or doesn't count sick leave for the first 90 days. The person said your employees start earning sick leave the day they start working. Okay? You can have a policy that says you can't take sick leave for 90 days, but they have to start earning it on day 1. Okay? Regular full-time employees, exempt employees, it's based on a 40-hour work week, even if they typically work more than 40.
Can you review that with salaried exempt employees, the whole master and sick time? And the other question is, if you decide to change your master and sick time to PTO wages, could you just review?
Sure.
Because I know a lot of companies have done that because they don't want to be collecting a doctor's note for
Yeah.
every, because they're busy. So
Right.
if you change it to PTO wages,
Right. Well, there's so 2 issues. Number one is exempt employees. It's your sick time is calculated on your regular hours. So if your policy is, hey, everyone works a 40-hour work week, it's 9 to 5 or whatever for your exempts, then it's going to be, the sick leave is going to be based on a 40-hour work week, which is 3 1/3 hours no, 1 1/3 hours, sorry, per week. That's what they're gonna earn. It can get a little bit dicey with your leave policies. Under Massachusetts law, you have to pay all vacation time at the termination of employment, separation of employment. Vacation time is considered wages. So you have to pay all earned vacation time. Sick leave, you don't have to pay, and paid time off, PTO, you don't have to pay. So a lot of employers about 20 years ago, when the laws were clarifying on vacation time, started changing over to just a PTO policy and not paying out at the end of employment. So you can have an all-in-one, and there's one danger, I'll talk about it in a second. You can have an all-in-one PTO policy and have no sick or vacation time. That's allowed, as long as your PTO policy complies with the Massachusetts sick leave law. So the people have to start earning, your employees have to start earning PTO on day 1. They have to earn at least a rate of 1 hour for every 30 hours worked. And they have to be allowed to use that PTO for the reasons enumerated in the sick leave law, which includes domestic violence, dealing with the effects of domestic violence, including going to court.
And you can expand that.
Oh, you can expand that. And here's where the danger comes in. There's a very old, I think it's 25 years old at this point, opinion letter issued by the Attorney General. And it states that if you have a PTO policy, and I don't put much credence in this, and I have disavowed it, but it's still out there and I have to mention it. If you have a PTO policy, a certain amount of PTO is designated as vacation time, if they can use it as vacation. And the rest can be designated as PTO, which doesn't need to be paid at the separation of employment. Now, never made sense to me. I've never advised my clients to do that. My advice is if you have PTO and you want to have a policy that says you don't pay it out at the end of employment, you don't have to. But I would avoid all language in your policy that talks about vacation, enjoying your time off, blah, 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 blah. I would focus on the sick leave language. You may take this to deal with, personal matters, a child or parent or loved one who's ill, your own serious medical condition, or just to take mental health time off or something like that. I would avoid the word vacation. So the Attorney General's point of view is that if they determine that you're giving sick time just to avoid paying out vacation time, or if you've adopted a PTO policy just to avoid paying vacation time, they'll deem it in an audit as some of that should have been vacation time. But the longer you've had that PTO policy in place, the safer you are. So if you had a PTO policy for 5 years and that PTO policy says we don't pay out at the termination of employment, you're likely to be very safe. The Attorney General has other things to worry about. Does that answer the question?
Yeah, it just is very confusing because it does say, even on the Department of Labor, Massachusetts.
Yeah.
It says it's wages.
For PTO.
Yeah.
Yeah. No, there's no case law for that.
Okay.
There's this one opinion letter. And again, PTO, to me, if you avoid language in policy.
For exempt employees, they get vacation.
Yeah.
Even hourly employees year-round get vacation
Vacation
time.
time.
But then they get this PTO, which is the master and sick time.
Right.
every
Right.
30 hours.
Yeah, and personal days and stuff like that.
Yeah.
No, that definitely does not. If you have a separate vacation
You
leave
do.
policy, you definitely don't have to pay PTO at the termination point.
Okay.
That's clear. Sick leave is not paid out, PTO. I've had one experience, it was a law firm actually that I did some employment work for. And they came to me and they had a split policy. They had a PTO policy. And then they had this 3-page long, very complex mathematical, a calculation on some of this will be considered vacation time and it depends on how long you worked and it changed over time. And we had them just go to a regular PTO policy. And now it's been 4 or 5 years in their state.
Okay, thank you.
You can deduct under Massachusetts law, you can take some deductions from employees, and we see it down here on the Cape for lodging and for meals. that have the effect of bringing the wage under minimum wage, the Massachusetts minimum wage. Now, I've had the Attorney General here, and I've spoken with them. Their opinion is no, you can't take any deductions that bring someone's pay under Massachusetts minimum wage, and that's incorrect, because the statute is clear and the regulations are clear. You can only deduct a very minimal amount. If it's lodging, a single room, and again, it has to be a room that is clean, potable water, habitable. You can deduct no more than $35 a week. A room occupied by 2 persons, $30, and by 3 persons, $25. And for meals, you can deduct no more than $1.50 for breakfast and $2.25 for lunch and dinner. Now, if you're going to have deductions for these things, for lodging and food, our suggestion is you make it very clear. You have the agreement in writing before the employee starts. And as Matt indicated, the more advisable way to handle this is through an agreement. Instead of deducting it from wages, having the employee cut you a check back for lodging and meals at the end of the month or every couple of weeks. That way, it seems much more like a business transaction. You don't fall into the trap of deducting from wages and draw the attention of Wage and Hour Division and the Attorney General. But again, you have to comply with the minimums. You can't deduct more than what these regulations say.
On here it says seasonal or temporary. What if they're year-round employees? Is that different?
Same thing. But we said seasonal because that's more typical. It's more typical to charge or to lodge an employee who's seasonal here on the Cape. Meals tend to be year-round. Again, as long as you have a regular policy, perhaps have an employee sign off on it, recognizing that they're going to have to pay meals and lodging. So, let's see. I'm not going to get into uniforms. Sort of jump ahead. We talk about civil monetary penalties and penalties under the Wage Act and under federal law. 2 weeks ago, and we were talking about this beforehand, the Massachusetts Supreme Judicial Court came out with a decision in the case of Reuter versus the city of Methuen. Methuen fired an employee. They're supposed to pay the employee their regular wages, that they're all earned wages on the last day of employment when you terminate an employee. Right? When an employee voluntarily leaves, you can pay them the next regular pay day. They have to get paid vacation pay and all earned wages. The city of Methuen paid the employee 2 weeks late. They fired her, cut her a paycheck. They paid everything. There was no dispute about that. The employee sued, actually had a discrimination case as well. And by the time this wound its way through and went up to the Supreme Judicial Court, the Supreme Court ruled that the employee, it was a violation of the Wage Act. The Wage Act is very harsh and unforgiving. And they awarded the employee triple damages for the lost wages, less the money that was paid. So if the employee was supposed to be paid $5,000 on the date of employment, and they were paid 2 weeks later, that employer now has to pay $15,000, triple damages, less the $5,000 they already paid, plus 12% interest, plus attorney's fees. And we see many, many cases where you might have an employer who is on the hook for $4,000, $5,000, $6,000 in back pay on a Wage Act violation, and the court awards $70,000, $80,000, $90,000, $100,000 in attorney's fees, because the attorney's fees are based upon how much time the attorney put in and the value of their services based on the market rates, called the lodestar method. So that is the danger of the Massachusetts Wage Act. It's very unforgiving. So if you've got to terminate an employee, right, even if someone engages in misconduct, you're getting rid of them right away. If you can't get them a paper check or direct deposit that day, and direct deposit has to hit their bank the day of termination, right? Not be processed, it has to hit their bank. Now, their bank may have restrictions. They may not be able to access that for a day or two, but it has to hit their bank, or you have to hand them a paper check. If not, our suggestion, we were talking about this, and what we've already advised several employers, is if you can't get a check out until the next day or a few days later, then extend employment. Tell the employee you're terminated, leave, but your official termination date is going to be Friday, the Wednesday or something, or the next day. It's going to be the end. It's worth paying that extra day or two to the employee to avoid a wage act violation. And really, that's the only two ways of complying when you terminate an employee suddenly is to get that person paid that day, including vacation time, or to extend their employment. You can tell them to leave. You're trespassed from the place. We don't want you here again. But your employment technically ends on Friday, and you pay them through the end of the week or
You
Thursday.
pay them what they were scheduled, or the minimum 3 hours a day if they weren't scheduled.
It would be what they're scheduled.
What they're
Yeah,
scheduled.
so if they weren't, you terminate them on a Wednesday.
Yeah.
If they were scheduled not to work on Thursday and scheduled for 4 hours on Friday, and you're gonna get them pay on Friday, it's only 4 hours.
Okay.
Right, so it's their regular schedule. So if they're not scheduled to work,
Mhm.
then in our opinion, then you can pay them that day and say that's when you're,
Yeah, I paid 3 hours the next day or
Yeah,
something.
yeah. And the safest bet is to pay them appearance time, 3 hours. And appearance time means no matter how long an employee may work, if they report to work, you've got to pay them at least 3 hours of working time, an hourly employee that day. So we see that on occasion too. Someone comes in, they clock in or they check in, and the employer of the restaurant will say, you know what, it's really slow, why don't you go head home? You still have to pay that employee 3 hours of pay that day.
Now, it may be a different approach to that is what if the employee asks to leave and it's been short of that period of time? They're not, I don't go to you and say, listen, we're slow, I'm sending you home. If you come up and say, hey, Matt, it's slow, can I go home? Are we still responsible for the 3 hours?
Yes. Yep. There's no exception to the appearance, rule.
Unless they were only scheduled 2 hours,
Nope.
right?
Doesn't
No?
matter how long they're
Doesn't
scheduled,
matter?
they
Okay,
have to get 3 hours of pay.
okay.
See, and under the Department of Labor, we would only enforce what they worked. However, because you're in Massachusetts, we always say, whatever law is more stringent is the one you have to follow. So therefore, you have to follow the state. We wouldn't enforce the 3 hours, but the state would.
I want to leave a little bit of time for questions, just very quickly. I've got a section here responding to government audits. If Nancy or Tom or one of their colleagues comes knocking on your door, typically you'll get what's called an audit letter informing you that the Attorney General of the Department of Labor is doing an audit. Sometimes you'll get a phone call. You want to either call your accountant or your lawyer. It typically means, in the case of the Attorney General, it always means someone's made a complaint against you. They don't have the staff to do spot checks and audits. The Department of Labor, as you heard, does do audits, and sometimes of specific industries, construction industry, very often random audits they'll do. And sometimes the hospitality industry too.
Yes, we do.
But if you get a knock on the door from the Attorney General, it's almost certain that someone has made a complaint against you, and it's going to be kept confidential. Typically, you're able to figure it out during the course of the investigation. You want to cooperate. You want to ask for more time if you need more time to get information together. Sometimes they ask for 2 years of payroll records. And if it's the high season, it's the middle of summer, say, listen, we're really crazy. Can we have a few extra weeks? You gave us 2 weeks to do this. And they're usually very understanding. Or can you limit the scope of this? Can we just give you the last year? Depending on what the complaint is, they may be willing to do that as well. They're fairly cooperative. You want to appear as cooperative as you can. If you appear to be pushing back and angry and defensive, you're not going to get the best treatment in the world. And finally, on the last page, I have some tips for terminating employees. They're all pretty much self-explanatory. And just a reminder, in Massachusetts, when you terminate an employee, you need to provide not only pay all earned wages the day of the termination, as of the termination date, you need to provide them with that unemployment form. And the unemployment brochure comes in multi-languages, many languages. So if you want, we've got the English language and the Spanish language ones at our office, electronic, but you can get on the website of the Department of Unemployment Assistance And they have downloadable forms there as well. Questions?
Anybody?
Just a question about the handouts. Everything's gonna be shared.
Just on it, when we do conduct an audit, my advice would be, because the employees are overwhelmed at all the stuff that we're asking for, payroll records. We usually give like a week to do it. If you can't get it within the week, I would just submit something, because if you're in the process of submitting, don't just say, oh, we'll get it to you in another 2 weeks, because then we'll issue a subpoena, and then it's complicated. So if you want to give us like a list of employees, your EIN number, the owner's names, it's all different information that's requested. And then the big chunk of it is time records and payroll records. If you need more time to get that, that's fine. We would say, oh, this employer is cooperating. They've given us partial records and they're working on getting the rest. So,
And if you've got it electronically, if you have an electronic timekeeping system, electronic payroll, which most people have electronic
Right,
payroll
that's what
these
we do
days,
pretty much.
the Department of Labor, the AG would prefer to get an electronic format.
you call whoever you use for payroll and they can send us over everything.
Yeah, they're very good at that. Any other questions there?
Well, it
Chat?
says here accrued holiday time, so is that if somebody accrued vacation and holiday time must be paid?
Well, if it's holiday time, if you pay a holiday,
A benefit, as a
benefit as a benefit, and you have a policy that says we pay 4th of, even if you don't work, we're not open 4th of July, but that's a paid holiday.
Okay.
That's seen as an earned wage.
If they were in that.
Yeah, so if they're terminated on
time
July
period.
8th,
Gotcha, okay.
they get paid the 4th of July holiday, like everyone else.
Yep, okay.
Anything else? Anything online? All right, well, thank you all very much. Again, the documents are going to be available to all those who registered. I'll leave some here as well. And so we'll.
Thank you.
Thank
Thank you very
you.
much.
Thank you.
Thank you. And remember, any questions, really call, because we have
And they
someone.
won't charge
on the- No, we have someone on the phones all day, and if they can't answer it, then we do call people back. Like, it doesn't go in the, this.
Yeah.
We call people back. That's what we
And if
do.
we don't have jurisdiction, we'll say, oh, that's a state law.
Yeah, call the state.
We'll tell you who to contact.
All right, thanks very much.
Thank
Thank
you.
you.